The slap echoed through courtroom 3 like a gunshot. I felt my water break before I hit the floor, and the man I had loved for 6 years, the man whose child I was carrying, stood 10 feet away and watched. He did not move. He did not call for help. He just straightened his tie. I remember staring up at those old courthouse ceiling tiles, the fluorescent lights humming overhead, and thinking with strange clarity, this is the moment. This is the moment everything either ends or begins. I just did not know yet which one it would be. The cold marble pressed against my back. My hands went instinctively to my belly. 8 months of precious life, 34 weeks of hope and fear, and yellow nursery walls and whispered promises in the dark. The baby kicked hard, as if he too understood that something had just broken wide open. A bailiff was shouting. Someone was calling for an ambulance. And across the hallway, a woman in designer heels stood frozen, her hand still raised, her face shifting from triumph to terror as she realized what she had done. She had no idea who was standing in the courtroom doorway watching her. She had no idea that the man in black robes, the man who would now hold every thread of my future in his hands, was looking at me with an expression that had nothing to do with judicial neutrality. She had no idea, and neither did I. But to understand how I ended up on that cold marble floor, I have to take you back to a Tuesday morning 6 months earlier, a perfectly ordinary Tuesday. The kind of morning that starts with coffee and ends with your entire world on the floor beside you. It started with a text message that was never meant for my eyes. Charleston, South Carolina moves slowly in the mornings. That was one of the things I loved most about living there. The way October light comes through the old live oak trees on Trod Street, filtering gold and green through Spanish moss. The way the air carries salt from the harbor and jasmine from 100 garden walls. The way the whole city seems to exhale before the day begins, as if it has all the time in the world and knows it. My name is Sarah Mitchell. I was 34 years old, 6 years married to Daniel Whitfield, self-made real estate developer, third-generation Charlestonian, the kind of man who walked into every room already knowing everyone in it, and made each person feel, somehow, like the most important one there. I know how that sounds now. I know exactly how that sounds. But back then, I believed it. I believed in the life we had built together, believed in the texture of it. Saturday mornings at the farmer's market on Marion Square, where Daniel always bought too many tomatoes and never remembered we didn't need tomatoes. Our golden retriever Biscuit, who had claimed the left side of our bed as his sovereign territory since the day we brought him home, and whom Daniel loudly complained about and secretly adored, sneaking him pieces of bacon when he thought I wasn't watching. The kitchen in our restored 1920s single house on Rutledge Avenue, where I made coffee every morning at 6:15 while Daniel did the crossword at the island, getting increasingly irritated by 7-letter words and refusing to admit he needed reading glasses. I had given up my career as a hospital social worker when Daniel's business expanded to 3 states. It was a decision we made together, he said. What he meant, though I could not see it clearly then, was that his schedule required my availability, and my availability required my schedule to not exist. I told myself it was a choice. I told myself it made sense. I told myself I would go back when things settled down. I was 7 months pregnant before I understood that things were never going to settle down, because the instability was not circumstantial. It was structural. It was designed. Here is something I want every woman listening to hear, because I wish someone had said it to me clearly before I needed it. Coercive control does not arrive wearing a sign. It does not announce itself with raised voices or slammed doors, or anything so visible that you could point to it and say, there. That is the thing. It arrives wrapped in love and provision and the particular warmth of being chosen by someone impressive. It works by replacing your preferences, slowly and pleasantly, with someone else's preferences, until the day you sit quietly and try to name one thing you want for yourself that is not filtered first through what he needs, and you cannot do it. By the time you see it clearly, you are already inside it. And that is not weakness. That is how it is designed to work. Daniel was not a violent man. I want to be precise about that, because when people hear certain words, they picture certain things. What Daniel did left different kinds of marks. He corrected me in front of people. Gently, pleasantly, the way you might correct a child who has said something endearing but inaccurate. He gave me the silent treatment for days when I disagreed with him, and when it ended, he never acknowledged it had happened, as if the previous 4 days had simply not occurred, and my confusion about this was the real problem. He told me I was too sensitive, too emotional, too much, and then in the very same breath told me I was the only person who truly understood him. He made me feel, on alternating days, like his greatest treasure and his greatest inconvenience. And I loved him. I want to be honest about that, because the love was real even when the man was not what I believed him to be. I loved the version of Daniel that existed in my understanding of him, which is its own particular kind of grief, mourning someone who may never have existed in the way you experienced them. I was 7 months pregnant. We had painted the nursery together in pale yellow, Daniel complaining the entire time about getting paint on his watch, both of us laughing at nothing in particular. I had believed in that yellow room that we were going to be all right. I had believed it all the way up until a Tuesday morning in March, when I walked into his home office to return his coffee mug and saw his laptop screen. He had left a calendar notification open. I almost did not read it. I was tired. The baby had been pressing on my sciatic nerve for a week, and I was moving carefully, the way you move when your body has temporarily become someone else's residence. I set the mug down and was already turning to leave when the words registered. Dinner, V. Canless, 8 p.m. Do not forget the necklace. I stood in the doorway. Then I sat down at his desk. The calendar notification linked to an email thread. I opened it. Her name was Victoria Harmon, 31 years old. Commercial real estate attorney, which meant she and Daniel moved in the same professional world, attended the same industry events, sat across from each other at the same conference tables. She had been at my baby shower. 3 weeks earlier, in the garden of our home on Rutledge Avenue, Victoria Harmon had stood holding a glass of sparkling cider. She had been very considerate about not drinking in front of the pregnant guest of honor, and told me that the nursery color was absolutely perfect, and that Daniel was so lucky to have someone who put so much love into their home. I had thanked her. The email thread went back 11 months. I read all of it. I do not know how long I sat there. Long enough that my coffee went cold. Long enough that Biscuit came and found me and put his head on my knee, which he does only when he senses something is wrong, which he almost always does before I do. The emails were not explicit. They were worse than explicit. They were tender. Daniel wrote to Victoria the way he used to write to me in the early years, with attention, with humor, with what felt like genuine delight in her existence. And then I found the line that I have turned over in my mind every day since. Once the baby situation is resolved, we can stop pretending. The baby situation. My son, 30 weeks developed, already responding to music by shifting and kicking, already someone I had named and dreamed about, was the baby situation. A logistical inconvenience, a complication to be resolved. I closed the laptop. I walked to the kitchen. I made tea because it was the only thing I could think to do with my hands. They were shaking so badly I burned my wrist on the kettle. I looked at the burn mark for a long time. And then I made the decision that I believe saved the life I was going to have to build from the rubble of this one. I decided not to say a single word. Not yet. The first call I made was to Margaret Calloway. I had heard her name from a colleague whose sister had gone through a difficult divorce 3 years earlier. Margaret was 58, a family law attorney with an office on Broad Street and a reputation for being the person you called when the other side had more money and thought that meant they had already won. Her first words to me, after I had explained the situation in a voice I was working very hard to keep steady, were, "Tell me everything, and do not leave out the boring parts. The boring parts are almost always the ones that matter in court." She said it with such cheerful matter-of-factness that I actually laughed. It was the first time I had laughed in 4 days. Then she said, "Now, let us talk about what you know and what you can prove, because those are two entirely different conversations." What I knew, Daniel was having an affair with Victoria Harmon, had been for nearly a year, and had at some point decided that the baby I was carrying was a problem to be managed rather than a child to be raised. What I could prove, I needed to find out. Margaret retained a forensic accountant named Bill Garrett. Quiet, meticulous, the kind of man who finds the same satisfaction in spreadsheets that other people find in sunsets. He began pulling financial records while I went home and continued being the wife Daniel expected me to be. I made his coffee. I attended his business dinners. I smiled at Victoria Harmon across restaurant tables on 2 separate occasions, asked about her work, and listened to her answer with what I can only describe as the focused patience of a woman who has decided that her feelings can wait until she can afford to have them. I want to tell you something about that period because people sometimes ask how I managed it, how I sat across from her and smiled. The answer is that I thought about my son every single time. I thought about the yellow nursery. I thought about what I was going to be able to give him, or not give him, depending on how the next months went. I discovered I was capable of far more than I believed, which is something that tends to happen when the stakes are high enough. Most of us are. We just do not find out until we have to. Bill Garrett came back to Margaret 6 weeks in with his first findings. I sat in her office on a Thursday afternoon in April, rain coming down steadily on Broad Street, and listened to him lay it out. Daniel had been transferring marital assets into a shell company, Whitfield Holdings, LLC, for 14 months. 14 months. The affair had been going on for 11. He had begun hiding money 3 months before Victoria, which meant this was not a man who had fallen recklessly in love and made desperate decisions. This was a man who had decided, deliberately, to exit his marriage, and had begun financially preparing for that exit, and had then, perhaps, found in Victoria the companionship that made the waiting bearable. Or perhaps he had simply been planning to leave regardless, and Victoria was incidental. I have never been certain which version is worse. "There is something else," Bill said, and he had the expression of a man who wished he were delivering different news. He slid a single page across the desk. It was a billing invoice from a private investigation firm hired by Daniel to investigate me. He had been building a file on me for 8 months, documenting my movements, my communications, my spending, my friendships, looking for something he could use. His investigators had been thorough and completely unsuccessful. I had done nothing wrong, said nothing damaging, gone nowhere suspicious. But he had kept looking anyway. I read the invoice twice. Then I set it down carefully. "He was afraid of me," I said. He was afraid of what you might find, Margaret replied, which means he always knew, on some level, that this day was coming. 10 days later, Daniel served me with divorce papers. He had filed first. His attorney was Crawford Hayes, silver-haired, 63, at Charleston Institution, who had been helping wealthy men manage their exits from marriages for 3 decades. Crawford wore his certainty like a second suit. He was very good at his job. I want to be honest about that, even now. The first mediation session was held in a conference room on the 14th floor of a building on Meeting Street with a harbor view. Daniel did not look at me when he entered. He looked at his phone, then at Crawford, then at a fixed point slightly to the left of my shoulder. In 6 years of marriage, I had never felt so completely invisible to him. Crawford presented the settlement offer, $180,000, no spousal support. And Daniel was requesting primary custody of our unborn son, pending a paternity test he was formally demanding. A paternity test. I had not been with another man in 6 years. Daniel knew this. Crawford Hayes knew this. The paternity test was not about doubt. It was about strategy, about planting a narrative, about framing me as the kind of woman whose character was in question before I had said a single word in my own defense. Margaret leaned toward me and said very quietly, "Do not react. That is exactly what they want." Then, after a brief pause, also, $180,000 against a $38 million estate is an insult so spectacular, I am almost impressed. Crawford usually has better taste. It was exactly the right thing to say. I pressed my lips together. I excused myself and walked to the restroom at the end of the hall. I went into the furthest stall and stood with my back against the door and let myself feel all of it, every bit of it, for exactly 4 minutes. Then I talked to my son. I pressed both hands against my belly, and I spoke to him out loud in a whisper in a 14th floor bathroom stall. "I do not know how to do this," I told him. "I want to be honest with you about that, because I think honesty is going to matter between us. I do not know how to do this, but I am going to figure it out. I promise you that." He kicked twice. I chose to interpret this as encouragement. I washed my hands, fixed my expression, and walked back into the conference room. "We will need time to review," Margaret said pleasantly. Crawford nodded with the graciousness of a man who assumed time would only help his position. He was wrong about that. 3 weeks before the hearing, a woman named Caroline Ashford reached out to Margaret's office. She was 41, the wife of Daniel's former business partner, a man Daniel had forced out of a joint development venture 2 years earlier in circumstances that had left the Ashford family financially damaged and genuinely bitter. Caroline said she had documents, financial records showing additional hidden assets beyond what Bill Garrett had already found. She wanted to help bring Daniel to account. Margaret and I met with her on a Wednesday afternoon. She was warm, precisely and convincingly warm. She described what Daniel had done to her husband with a specificity and a quiet, controlled fury that felt authentic. She was angry in all the right ways, and for what seemed like all the right reasons. She slid a folder of documents across the table with the air of someone who had been waiting a long time to do exactly this. I liked Caroline Ashford. I liked her immediately, and I trusted her more quickly than I should have, and I am not ashamed of that. I understand it now as entirely human. When you have been isolated long enough, when you have been managing your fear alone for weeks, warmth feels like water in a desert. You drink it before you think to ask where it came from. Margaret's paralegal, a thorough young man named Thomas Webb, ran a standard background check 2 days later as a matter of routine procedure. He came into Margaret's office while I was there and set a single sheet of paper on the desk without saying anything. Margaret read it. Her expression did not change. That meant it was bad. Caroline Ashford's maiden name was Harmon. She was Victoria's older sister. The documents in the folder were sophisticated forgeries, detailed enough to appear credible, flawed in ways that a forensic accountant would catch. If Margaret had submitted them, we would have been exposed using fraudulent evidence. We would have lost everything. Margaret would have faced bar proceedings. My case for custody would have collapsed entirely. Thomas had found it 24 hours before we planned to file. 24 hours. I sat in Margaret's office, listening to her explain what had almost happened, and I felt something cold settle over me that was not quite fear and not quite rage, but was some precise combination of both. She was so convincing, I said. She was motivated, Margaret replied, and she was smart. Do not blame yourself for not seeing it. You were not supposed to see it. That was the entire design. I thought about Victoria at my baby shower, the sparkling cider, the compliment about the nursery color, the hug. What kind of person, I said slowly, sends their sister to do this? Margaret looked at me steadily. The kind of person you are divorcing, she said. Now, we have 3 weeks. Let us talk about what we are going to do with them. I want to speak directly to anyone listening who is in the middle of something like this. When you are vulnerable, when you are desperate enough for an ally that a hope bypasses caution, predators can sense it. They will offer you exactly what you need most, timed for the moment when you are least likely to question it. This is not a reason to trust no one. It is a reason to slow down, to let the people in your corner do their jobs. Your desperation is not a character flaw, but it is a vulnerability, and the people who want to hurt you know exactly how to find it. The hearing was in 3 weeks. I was 8 months pregnant, out of tricks, and running low on time, but I was not yet out of fight. I woke at 4 in the morning on the day of the hearing. I lay in bed for 20 minutes, listening to Biscuit breathe at my feet, a sound I have always found inexplicably comforting, the slow, absolute certainty of a sleeping dog who has no concept of courthouse hearings or asset transfers, or the particular anxiety of a woman who has spent 6 weeks preparing for the most important day of her life and still does not feel ready. Then I got up because lying there was worse than moving. I went to the nursery. I sat in the glider we had found at an estate sale in Mount Pleasant, a 1970s piece that creaked faintly and was possibly the most comfortable chair in the world. The room was dark, except for streetlight coming soft through the curtains. The pale yellow walls held the darkness gently. I talked to my mother. Her name was Helen Mitchell. Helen before she married. Helen after, because she said she had always liked being a Helen and saw no reason to complicate a perfectly good name. She had died of pancreatic cancer 2 years earlier, 14 months after diagnosis, with the same organized practicality she brought to everything. She had pre-addressed the thank you notes for her own memorial service. I am completely serious about that. She had not liked Daniel. She had been too tactful to say so directly while she was alive, which was its own form of communication if you knew how to read her silences. I told her I was terrified. I told her I did not feel ready. I told her I wished she were here in the particular way you wish for people who cannot come back, fully, uselessly, with your whole chest. Then I got up and got dressed. I chose the blue dress she had given me 2 Christmases before she died. You walk into a room the way you want to be treated, she had told me when I opened it. So, walk in like someone who deserves to be there. I clipped Biscuit's leash and took him around the block in the pre-dawn dark, the air thick with salt and jasmine, and let him sniff everything he wanted to sniff. He was spending the day with Ellen Whitfield, Daniel's aunt, the only member of his family who had called me since the separation to ask how I was holding up. He probably gets the dog and the divorce, I told Biscuit as we walked. Crawford Hayes will find a way to make it happen. Biscuit looked up at me with the untroubled expression of a creature who had genuinely never considered that life might be unfair, and I found this deeply, specifically comforting. I dropped him at Ellen's. She held both my hands at her front door and said, with quiet certainty, "You are going to be all right." I drove to the courthouse on a morning that smelled like October and salt water and the particular sharp clarity that comes before a storm. I walked in like someone who deserved to be there. The Honorable Robert Patterson had been on the family court bench for 19 years. He was 61, silver-haired, with the permanent, composed expression of a man who had heard every version of every marital dispute that human beings are capable of generating and was prepared to be patient while hearing it again. He entered at precisely 9 o'clock, and everyone rose, and I thought, this is it. This is where it gets decided. Margaret was beside me in her gray suit. Her, we mean, business suit, as she had described it, with a better courtroom record than the blue one. Daniel and Crawford Hayes sat at the plaintiff's table. And behind Daniel, in the gallery, where she had no legal standing whatsoever, sat Victoria Harmon. She was there as a statement. She was wearing a necklace I did not recognize. I looked at it for one moment. Then I looked away, because she was not the point. She had never really been the point. Crawford opened with practiced ease. Sarah Mitchell was emotionally fragile, financially inexperienced, and her claims to marital assets were substantially overstated given her limited contribution to her husband's business success. He said the words limited contribution with such smooth neutrality that the insult almost did not register. Almost. Margaret presented Bill Garrett's forensic analysis. The 14 months of asset transfers, the timeline placing the first Whitfield Holdings transfer 60 days after my pregnancy was confirmed, the methodical documentation of a man who had been planning his exit while I was buying nursery furniture. Judge Patterson was unreadable. He took notes in a small leather notebook. He asked 2 clarifying questions, both precise. During the morning recess, I walked into the hallway. Victoria was there. Daniel stood nearby, turned away, his phone to his ear. She waited until she was certain he was not watching. Then she crossed to me. Her voice was very quiet. "You should take the offer, Sarah. He is going to take you apart in there, and you know it. Walk away with something while you still can. That baby deserves a mother who is not being humiliated in open court." I said nothing. Margaret had coached me on this. Stillness. Give nothing. Be unremarkable. Victoria stepped closer. "He never loved you. He told me that on our first night together. He said marrying you was the most boring mistake he ever made." I turned to walk away. She grabbed my arm. The grip was harder than I expected, hard enough to throw me sideways. I pulled back instinctively, and then she slapped me, open-handed, hard enough that the sound carried through the marble hallway like something breaking. I felt the impact before I fully processed it. And then I felt something else. Lower, different. Nothing to do with the slap. A shift, a release of pressure, warmth. I looked down. Then I looked up at Daniel. He was staring at me from across the hallway, his phone still in his hand. He took one step toward me and stopped. He stood there and did the calculation. The cost, benefit, optics, what a step forward might mean for his case. At the source, and stopped. I want you to hold that image, because that one step, that hesitation, that was the moment I stopped grieving my marriage. You cannot grieve something that was never real. And watching him stand there, running the numbers, while I stood in a puddle of amniotic fluid on a courthouse floor, I understood, all the way down and for the very first time, that it had never been real. Not for him, not in the way it had been for me. I was not sad. I was free. Then the pain arrived, and I stopped being philosophical about anything. The first catastrophe happened on the courthouse floor. A woman appeared beside me, on her knees on the marble, which, given the quality of her clothing, suggested she had decided her dry cleaning bill was not relevant to the current situation. She was in her early 40s, auburn hair, with the kind of composed stillness that comes from long practice managing crisis. "I am Ellen Whitfield," she said, "Daniel's aunt. I have been trying to reach you for 3 months." I stared at her. "You are the one who kept Biscuit today." Yes, a flicker of something, amusement and grief living in the same expression. "And I have a USB drive in my bag that your attorney needs to see immediately. There is a provision in the original Whitfield Family Trust that Daniel's lawyers buried. It concerns the marital home. Sarah, you have rights he does not know you have." The EMTs were coming through the main doors. Ellen pressed the drive into my palm. "Give this to Margaret." "And there is something about the judge." "I need to tell you about the judge, but it has to wait." They loaded me onto a stretcher. Through the closing doors, I saw Judge Patterson still standing in the courthouse entrance, still watching. His face held something that was not judicial, something personal, shaken, unguarded, an expression I could not yet name. I held the USB drive closed in my fist all the way to the hospital. The second catastrophe arrived while I was in labor. My son was positioned awkwardly and arriving early, and had apparently decided that if the day was going to be dramatic, he intended to contribute fully. I was in a labor room at the medical center with a midwife named Barbara, who had the calm authority of someone who had safely delivered 1,000 babies and found panicking about it inefficient. My contractions were 4 minutes apart when Margaret called. She did not begin with a greeting. "Daniel has filed an emergency motion." I closed my eyes. "He is using the courthouse incident, the physical altercation, your emotional state, as evidence of an unstable environment. He is requesting temporary emergency custody of the baby upon birth, before any permanent arrangement is determined by the court. He filed it while I was in the ambulance. Yes. I want you to hold that image for a moment." A woman in active labor, alone in a hospital room, being told that the man who had watched her fall, who had taken one calculating step and stopped, was filing paperwork to take her newborn son before she had even held him. This is something I need to say plainly, because it matters. What Daniel did in that moment is not unusual in high-conflict divorce situations. Filing an emergency motion while the other party is in crisis is a tactic designed to catch you at your most vulnerable, to force your attorney to respond under pressure, to frame your completely reasonable human distress as evidence of instability. Courts have seen this before, which is why having an attorney who has seen it before is not optional. It is the difference between surviving the maneuver and being destroyed by it. Margaret had 2 hours to respond before a duty judge ruled. The duty judge was Robert Patterson. Margaret filed the countermotion. 45 minutes later, Patterson denied Daniel's emergency request. My son was born 17 minutes after that. 7 pounds, 2 ounces, dark hair. The most astonishing thing I had ever seen in my life. I named him James, my father's name, James William Mitchell. I held him, and I cried, and Barbara handed me a tissue with the efficiency of someone who had yet handed out 10,000 tissues and found this a completely sensible response to the circumstances. For 47 minutes, I held my son and believed the worst was behind us. Margaret arrived at the hospital 2 hours after James was born. She had her work expression on, focused, steady. Nothing escaping. She sat in the chair beside my bed, opened her laptop, and I knew before she spoke that something significant had shifted. The trust document is real, she said. Ellen was right. There is a provision giving you a legitimate claim to the marital home, regardless of how it is currently titled. That is genuinely significant. But, I said, but that is not all that is on the drive. She turned the laptop toward me. There was a folder of correspondence between Daniel and Crawford Hayes going back 19 months. Billing, case strategy, routine documentation, and then, in a memo from 15 months ago, a name appeared in the margin. Circled in pen, Robert Patterson. Beneath it, 3 words, confirm availability, priority. He requested the case, I said, through a procedural assignment mechanism that is technically permissible but almost never used, Margaret said. He asked a court administrator, a personal connection of long standing, to route this specific case to his docket. Why? Margaret closed the laptop. That is what Ellen needs to explain. Ellen came that evening. She sat across from me with James asleep in the crook of my arm, and she told me the truth about Robert Patterson. He and Daniel's father, George Whitfield, had been college roommates, fraternity brothers, the kind of friendship that spans decades and favors and quiet understandings between men who accumulate power and know how to use it on each other's behalf. When George died 6 years ago, Patterson had become the Whitfield family's informal protector, not legally, not on paper, but in the way that old alliances between powerful men sometimes solidify into arrangements that nobody names out loud. He had requested this case to protect Daniel, to be the insurance policy, to ensure the outcome was managed. But there is something else, Ellen said. She reached into her bag and produced a photograph in a plastic sleeve. The photograph was old, the color slightly faded, the edges soft. A young woman, perhaps 22, standing outside a courthouse, visibly pregnant. Smiling the slightly dazed smile of someone who is hoping very hard that good news is coming. On the back, in Ellen's handwriting, Mom, 1987, 3 months before she died, Ellen's sister-in-law, George Whitfield's wife, Daniel's mother, had brought a wrongful termination lawsuit against a former employer in 1987. She was young and pregnant, and the evidence was credible. The case was dismissed on a procedural technicality. Robert Patterson had been the judge. She developed complications, Ellen continued. She was 23. The settlement from that lawsuit had been her financial lifeline. She had planned to use it for proper medical care. Without it, the care she needed was out of reach. She died when Daniel was 18 months old. George Whitfield and Robert Patterson had dinner to celebrate the dismissed case the following week. I found the reservation in my father-in-law's papers after he died. The room was very quiet. Patterson had protected that family when it benefited him to protect them, I said slowly. He has been protecting them ever since. Yes, but he protected me today. He denied Daniel's emergency motion. Ellen's voice was careful. I do not know what he saw when he walked out of that courtroom and found you on the floor. I do not know what he remembered. But something changed, and you need to decide what to do with what you know. Because if he remains on this case, he cannot remain on this case, I said. I looked at James. He cannot. Margaret laid out the options with her careful, thorough precision. Option 1. File formally for recusal based on conflict of interest. Public, direct, a frontal challenge to the establishment. Delay the hearing by months. Option 2. Use the information as quiet leverage. Let Patterson know through appropriate channels that we had the documentation. Encourage voluntary recusal without public confrontation. I listened to both. Then I said, neither. We go to Patricia Reynolds. Patricia Reynolds was an investigative journalist at the Charleston Courier who had been covering courthouse administration and judicial conduct for 11 years. Margaret knew her professionally. Her record was careful and thorough, and she had a reputation for sitting on stories until every fact was nailed down. Margaret went still. "Sarah." "I know what it is," I said. "Do it anyway. If you do this, it becomes public. It becomes—" "Silence has already cost me enough," I said. "If Patterson recuses, voluntarily, Patricia holds the story. There is nothing to publish. If he does not, she publishes, and the case moves to a judge who does not have 35 years of Whitfield loyalty built into his rulings. Either way, James gets a fair hearing. That is the only outcome that matters." Margaret looked at me for a long moment. Then she picked up her phone. "I want to say something about that decision directly, because it is the one I am asked about most. There is a version of that moment where I stayed quiet, accepted the leverage arrangement, managed the situation through back channels, stayed manageable. I understand why that version is appealing. It feels safer. It feels less exposed. It does not require you to become someone who makes noise. But here's what I have learned. The systems designed to silence women do not become less effective because you cooperate with them politely. Silence does not make those systems smaller. It makes you smaller. And I had spent 6 years already becoming smaller, one comfortable accommodation at a time. I had given up a career, a social circle, a professional identity, and eventually, very nearly, a home and a son. All in the service of keeping things manageable. Manageable for whom, exactly? The choice to speak is its own form of protection. Every woman who speaks makes it marginally more possible for the next woman to be heard. This is not heroism. It is just how change actually works. One woman, one voice, one decision to stop making herself small. Margaret called Patricia Reynolds. Patterson recused himself 4 days later, citing a conflict of interest he had failed to identify at the outset of the case. His statement was brief and carefully worded. Patricia held the story. 3 weeks later, new courtroom, new judge, the Honorable Susan Marchand, 54, family court veteran, with a reputation for meticulous attention to financial evidence and zero patience for procedural maneuvering. She entered the courtroom, and I felt, for the first time since this entire ordeal had begun, that I was in a room where the outcome had not been decided before anyone sat down. Crawford Hayes entered, looking like a man who understood this too. The shift was subtle. Something in the set of his shoulders, the way he reviewed his notes twice. But Margaret noticed it and gave me a small, satisfied nod. Victoria was not present. She and Daniel had retained separate counsel. They were no longer together. Margaret leaned toward me as we waited. "Interesting how quickly a man discovers his soulmate is a liability," she said pleasantly. "Must have been a very deep and genuine connection." It was exactly the right thing to say. I almost smiled. The hearing proceeded with methodical care. Bill Garrett presented the forensic analysis. Ellen testified about the trust provision. Margaret introduced the 14-month asset transfer timeline with the patience of someone laying out evidence that speaks entirely for itself. Daniel took the stand. He was good, carefully coached, controlled, credible. He told a version of the story in which he was a man who had tried sincerely to save a difficult marriage and had ultimately been unable to do so. He was sympathetic. He was composed. He made eye contact with the judge at exactly the right moments. He was doing well. Then Margaret stood for cross-examination. She was unhurried. She established the timeline with pleasant, methodical precision. She walked Daniel through the Whitfield holdings, transfers one by one. Then, "Mr. Whitfield, when did you first consult an attorney about divorce proceedings?" Crawford objected. Overruled. After I realized the marriage was not working, Daniel said carefully. And when was that approximately? About 14 months ago. 14 months ago, Margaret said, as if simply confirming a detail. Your son James was conceived approximately 15 months ago. Is that correct? The courtroom was very quiet. Yes. So you began consulting divorce attorneys and initiating the transfer of marital assets within 60 days of learning your wife was pregnant. Daniel started to answer. The same 60 days, Margaret continued, her voice entirely pleasant, in which you transferred $400,000 into Whitfield Holdings LLC. While your wife was managing her first trimester, while she was painting a nursery yellow on Rutledge Avenue, she let the silence sit. Nothing further. Judge Marchand's ruling came 8 days later. Equitable distribution, 42% of marital assets to Sarah Mitchell, including full title to the marital home on Rutledge Avenue, upheld by the Whitfield Trust provision Ellen had uncovered. Spousal support, 4 years. Primary physical custody of James William Mitchell with Sarah. Daniel would have regular scheduled visitation. Victoria Harmon pleaded guilty to misdemeanor assault. Community service, a fine, a permanent record. Crawford Hayes filed to withdraw from all Whitfield matters the following month. The Judicial Review Board opened a formal investigation into Robert Patterson's conduct. He retired before it concluded. Patricia Reynolds published her story 6 weeks after the hearing. It ran on the front page of the Charleston Courier and was the most read piece the paper had published in 4 years. I want to be honest with you about what winning felt like, because I think honesty about this matters. It did not feel like the movies. I did not walk out of Margaret's office when she called with the ruling and feel orchestral music swelling or the clean satisfaction of a closed door. I sat down on my kitchen floor, James on my hip, Biscuit materializing immediately from wherever he had been sleeping and pressing his warm weight against my leg the way he does when something significant is happening. And I cried, not sad crying, not happy crying, exactly. The kind of crying that has been waiting inside you for so long that when it finally comes, it does not have a shape anymore. It is just weight, leaving. I sat on the floor of the house that was now mine and cried until I was empty, and then I looked at my son, and then I fed the dog, and then I made coffee. And I began. James is 11 months old. He has his father's nose, which I have made my peace with, and my mother's eyes, which I find every single day to be an unexpected and specific kind of grace. As if she left something essential in him on her way out of the world, something that catches the light the same way she did. He is loud and determined, and has recently become passionately interested in Biscuit's ears as an object of study, a fixation that Biscuit tolerates with the long-suffering dignity of a dog who has seen things and survived them. I went back to work 4 months after James was born. Hospital social work, part-time at first, and then full-time. I work primarily with patients navigating domestic situations, women at the particular crossroads, where the practical and the devastating intersect, where the next step seems impossible, and someone needs to sit with them and say, "It is not." I have sat in that chair on both sides of the desk now, and I want you to know that changes how you hold space for someone. It changes everything. I walked back into the job I had given up, and they gave me a caseload that felt, as I told Margaret on the phone one evening, like the universe had a very specific sense of humor. The universe is frequently efficient, Margaret said, and sent me a plant for my office. It is still alive. This feels significant. Ellen Whitfield comes for Sunday dinner sometimes. She and Biscuit have reached a private arrangement that involves her giving him pieces of whatever we are having, and him pretending not to notice when she moves his bed slightly so she can reach the bookshelf. I find this arrangement completely acceptable. She has become, in the particular way that chosen family sometimes forms from the wreckage of other things, one of the steadiest people in my life. Margaret sends a card on James's birthday. This year's said, "To the boy whose mother chose the hard, right thing over the easy, wrong one. He will understand someday. He may even thank her." I keep it on the refrigerator. Daniel is remarried, not to Victoria, to someone new, someone I do not know. I find, genuinely, and to my own slight surprise, that I do not wish them harm. I hope he treats her better. I hope she knows her rights from the beginning and keeps her name on everything and never gives up a career for someone else's convenience. I hope she is happy and that happiness requires nothing from her that she is not freely choosing to give. I find I do not hate him. I do not miss him. I feel about him the way you feel about a serious storm that damaged your house. A residual alertness to weather, a new understanding of what the structure can withstand, and a deep, quiet gratitude that it passed and you are still standing in the same place. Victoria completed her community service and has moved to another city. The Judicial Review Board concluded its investigation of Robert Patterson last spring. He did not return to the bench. I think about him sometimes. About that moment in the courthouse entrance when he stood watching the EMTs load me onto a stretcher, wearing that unguarded expression I spent weeks trying to name. I think I understand it now. I think he saw something that cracked open. Briefly, whatever arrangement he had made with himself about what he was doing and why. I do not know if that is enough, morally speaking. I do not know if the belated doing of the right thing is sufficient accounting for a long prior history of doing otherwise. What I know is that his one small act of decency, denying Daniel's emergency motion while I was in labor, meant that James came home with me, and I find I cannot carry bitterness about a man alongside that fact. Not neatly, not without contradiction. So I hold both. I think that is probably what honesty requires. I am not healed. I want to say this plainly because the way we talk about recovery sets people up for a kind of confusion that I think causes real harm. There is no finish line. There is no morning you wake up and it is simply over, resolved, filed away. I still flinch when legal envelopes arrive in the mail. I still have nights where I replay the years and look for the moments I should have seen and did not. I still sometimes catch myself automatically arranging my preferences around an imagined other person's comfort before I remember that I no longer have to do that. That I am allowed, now, to simply want what I want. Healing is not a destination. It is a direction. Most days I am moving in it. Some days I am moving more slowly than others. I have stopped requiring myself to move at a particular speed. My son is 11 months old. He does not know any of this yet. The courthouse, the marble floor, the slap that echoed, the 47 minutes of false peace before Margaret's call, the drive, the photograph, the judge's unreadable face. He does not know about the yellow nursery, or the burns on my wrist, or the 4 minutes I spent in a bathroom stall, talking to him before he existed outside of my body. He will know someday. I will tell him all of it, when he is ready, in the way that honest mothers tell their children hard truth, carefully, completely, without making him carry what is not his to carry. I will tell him that his grandmother Helen pre-addressed her own memorial thank you notes and wore a blue dress on her best days and told me that you walk into a room the way you want to be treated. I will tell him about Margaret's gray suit and Bill Garrett's spreadsheets and Ellen on her knees on the courthouse marble in clothes she did not care about ruining. I will tell him about Biscuit, who always knew before I did, and I will tell him about the choice. The one I sat with in a hospital bed, holding him for the first time, When Margaret asked if I was sure, and I said yes. The choice to speak. The choice to stop being manageable. I will tell him that the most important thing I did in my entire life, before he arrived, before the courthouse, before any of it, was the night I sat at his father's desk and made a decision to say nothing yet, to prepare, to gather what I needed before I moved. And the second most important thing I did was the night in the hospital when I made a different decision and said, enough. We go to Patricia. We go public. Silence has cost enough. Both of those things were true at the same time. Sometimes strategy requires your voice, and sometimes it requires your silence, and the wisdom is in knowing which moment you are in. I am still learning that. I suspect I will be learning it for the rest of my life, which seems about right. Outside, October is coming back to Charleston. The light through the oaks on Trad Street is going gold again. The air smells like salt and jasmine and the particular clarity that comes before a change in weather. James is asleep in the next room, making the small sounds he makes when he is deeply, completely at rest. Safe sounds, I call them. The sounds of someone who does not yet know he has anything to be afraid of. I am working very hard to keep it that way. If any part of this story felt familiar, if you recognized something in the way the control arrived so quietly, wrapped in love and provision, if you recognized the slow erosion, the explained away wrongnesses, the moment of standing in a kitchen with shaking hands, not yet understanding fully what you know, if you recognize the impulse to stay quiet, to prepare in secret, to protect something before you moved, if any of it felt familiar, I need you to hear this. You are not imagining it. You are not too sensitive. You are not overreacting. The shame of what is happening to you belongs entirely to the person doing it. Not to you, never to you. And you are not alone. If this story moved you, if it made you feel bad, think of someone you love, or something you have survived, or something you are still in the middle of, share it. Not for the numbers. Because somewhere, right now, another woman is sitting in a parking lot, or a nursery she painted alone, or a bathroom stall, trying to decide if what she is feeling is real and whether she is allowed to act on it. Sometimes, the thing that tips the balance is simply knowing that someone else made it through. Leave a comment and tell me which moment stayed with you. I read every single one, and subscribe, because next week's story is already waiting, and you are going to want to be here for it. Closing lesson, I want to spend the last few minutes with you on what I believe this story is truly about. Not the courtroom, not the slap, not the legal strategy, though all of those things matter. The deeper thing, the thing underneath. The first lesson is this: coercive control does not announce itself. It arrives wearing love. It arrives as provision and devotion and the particular warmth of being chosen by someone who seems to have so many options. It works by replacing your preferences, one small accommodation at a time, until the day you sit quietly and try to locate what you want, separate from what he needs, separate from what keeps the peace, and you cannot find it. It is not gone. It has just been buried under years of making yourself smaller to fit the space you were given. The antidote is not suspicion. It is awareness. Knowing the names of what you are seeing, because you cannot protect yourself from something you cannot name. The second lesson, preparation is not betrayal. Sarah's choice to gather information before confronting Daniel was not dishonest. It was survival. In a relationship where power sits entirely with one person, transparency is a luxury the less powerful partner cannot always afford. Protecting yourself, knowing your rights, understanding what you own and what is owed to you, these are not acts of distrust. They are acts of dignity. Know your account numbers. Keep your name on the important documents. Understand the financial structure of your shared life. Not because love requires suspicion, but because dignity requires information. The third lesson: the system is not automatically on your side, but it can be navigated. Crawford Hayes existed. Robert Patterson's quiet arrangements existed. The machinery that helps people with more resources manage their exits from marriages exists. And it is not going to disappear because it is unfair. This is not a reason for despair. It is a reason for preparation. Find an attorney who has seen this before you need one. Understand the process before you are standing in the middle of it. Do not wait for fairness to find you. Go find it. The fourth lesson: winning looks different than you expect. Sarah did not get everything. She got what was fair. Fair is not the same as whole, and it does not return the years or restore the person you were before any of it began. What she got was a home, a son, work that mattered, and her name. And something harder to name but more durable than any of those things: the knowledge that she could be broken. Completely broken, on a courthouse floor, in labor, in a hospital bed at midnight, and not stay broken. That is not a small thing. That may in fact be the only thing. And the last lesson, the one I most want you to carry with you when you leave today: the choice to speak is its own form of protection, not recklessness, not drama. A clear-eyed understanding that silence has a cost, and that sometimes the cost is one you have already paid too much of. Every woman who speaks makes it slightly more possible for the next woman to be heard. This is not heroism. It does not require courage of the movie variety, the kind that arrives fully formed and certain. It only requires the willingness to say, enough. I have been quiet enough. I have been manageable enough. I have been small enough. I am done with enough. You are not behind. You are not too late. You are not too broken or too tired or too deep in to find your way out. You are exactly where you are, and that is the only place from which you can begin. An important note before you go: the story you just heard is a dramatic narrative created for entertainment and emotional reflection. It is not based on any single real person or real legal case. All characters, names, locations, and events are fictional and have been constructed for storytelling purposes only. The information shared in this story, including references to financial documentation, legal procedures, and divorce proceedings, is presented for narrative context only and does not constitute legal advice. If you are navigating a difficult personal or legal situation, please consult a qualified attorney or licensed professional in your area. This story was researched, written, and produced by our team with care and intention. All emotions are real. All lessons are offered in good faith. Thank you for being here. We will see you in the next one.